Please be aware, in this podcast series we talk about all areas of safeguarding, which some people may find upsetting. So please make sure you're okay listening to today's topic. Be mindful of those around you, such as children, that you might not want to listen in. Hi, I'm SSS Safeguarding Director Sam Preston.
And I'm former head teacher and content author Sara Spinks.
Welcome back to the Safeguarding Conversation podcast. Today we're exploring the major shift in family court reporting rules in England and Wales. Changes that have been called a watershed moment for family justice.
That's right, Sam. You know, for the first time, journalists and legal bloggers now have greater freedom to report on family court cases. So this is a real significant change aimed at increasing transparency and improving public confidence in the system.
Absolutely. Now, up until now, family court hearings were held in private. Journalists could attend, but they weren't allowed to report on proceedings. And that's all changed following a 2-year pilot programme. Now, journalists can report on cases, quote from court documents, and even approach families, as long as they protect the anonymity of the children and families involved.
And I believe these changes are being introduced in stages. Am I correct?
Yeah, that's right, Sarah. They've been rolled out in 3 phases. So first, they apply to public law cases. That's things like care proceedings involving local authorities. Next, they'll extend to private law cases, which includes disputes between parents. And finally, they'll be implemented into magistrates' courts, which handle many family cases.
It's a really big shift, this, isn't it? You know, why do you think it's happening now, Sam?
Well, the main driver is public trust. Sir Andrew McFarlane, who's the president of the Family Division, has stressed that family courts need to be more transparent so the public can understand how decisions are made. The pilot programme showed that responsible reporting can take place without compromising the privacy of children, and it brought attention to some crucial family justice issues, like children being placed under deprivation of liberty orders, the removal of parental rights from convicted paedophiles, and cases of neglect and child abandonment.
So it's about increasing public awareness while still safeguarding vulnerable children. But not everyone is fully on board, right? You know, what concerns have been raised about this?
That's right. And I have to say, I have some concerns about this too. I'm not against it, but I do have some concerns. So while many support the move, some legal experts and child protection professionals have voiced concerns. And the 3 sort of biggest issues are, firstly, selective reporting. So the media may focus on dramatic cases, giving a really skewed perception of the system. And let's face it, we see that with child protection cases when eventually verdicts are reached and whatnot, and it all comes out in the news. We've seen that skewed portrayal. The second is sort of jigsaw identification. So even without names, people might piece together details and figure out who's involved. And that, for me, I think is probably my biggest risk here. And I know I've actually had experience of that happening in the past, where you think you've taken a lot of care and actually people have been able to put that jigsaw together.
And I think that's even heightened now, isn't it, Sam, with social media usage and everybody having real access to lots and lots and lots of information all the time.
And there are no borders, there are no boundaries. No. You know, it's not a case of moving to other areas. You know, there is really no such thing anymore.
Yeah.
And then that takes us to the third issue I think that people have is the privacy risks. Some argue that family court matters should remain private to protect children and families from unnecessary distress.
Yeah, I think that makes sense. You know, a child reading about their own case in the media years later, it could be really upsetting, doesn't it? Did any experts comment on this?
Yeah, I mean, several professionals have really weighed in on it. We've had a family justice expert who highlighted the need for balanced media coverage, not just, as we've said, the sensational cases. Legally, we've had warnings that journalists, they're going to have to be really careful about what they publish, since even, anonymised reports can sometimes reveal identities. And also there was a Children's Guardian representative that emphasised the emotional impact on the children, which I think children need to be at the heart of this. That's what safeguarding practice is all about with children. And they've reminded the media that these reports, they may be read by those directly affected in the future. These reports live on well beyond the media moving on.
Yeah, I think that's a really important point. And this debate about openness versus privacy ties into a major Court of Appeal ruling that happened recently. Can you tell us about that case involving Sarah Sharif, Sam?
Yeah, I mean, this was a really significant ruling. The Court of Appeal recently overturned a reporting restrictions order that had prevented the naming of 3 family court judges who were involved in Sarah Sharif's case before her murder in 2023. The High Court initially imposed the ban, citing concerns about social media abuse. But major media organisations challenged this, arguing that judges should be held publicly accountable for their decisions. The Court of Appeal ruled that the anonymity order had no legal basis. The judges' names were then made public after a short delay to allow security measures to be put in place.
So this ruling reinforces the principle of open justice and judicial accountability then?
Exactly. And combined with the new reporting rules, it marks a big shift towards greater transparency in family law.
So now that these reforms are in place, what does this mean for the future of family court reporting?
Well, it's the start of a new era, really. We're likely to see greater public confidence in family courts and more scrutiny of decisions affecting vulnerable children. And hopefully we'll see a balance between media freedom, public interest and child protection. But you can tell I'm being cautious here. Challenges remain. The success of these reforms will depend upon responsible reporting and ensuring safeguards remain in place. And when I'm saying responsible reporting, what we can't really factor into that is social media commentary.
Absolutely. So it's a major step, isn't it? It's a crucial major step. But I suppose that maintaining the right balance is going to be fundamentally crucial to this. Yeah. So I think before we wrap up, Sam, what's your take? Do you think these changes are a positive move?
I think transparency is important. It's very important. But it needs to be handled with care. And given the public insight into family courts, that can build trust in the system. But we must ensure children and families are not put at risk in the process. So responsible journalism's key. That's reporting the facts without sensationalising cases. But I do have real concerns about social media.
Absolutely, I completely agree. And I think it's all about openness without harm. I think that's key.
Absolutely. It will all be about getting that balance between transparency and safeguarding right. And I've no doubt we'll be returning to this topic as things develop. I think this is an ongoing conversation, and I'm quite sure we'll be revisiting certain aspects that we've covered in this podcast again. So I hope you've enjoyed listening to this. Don't forget, all our Safeguarding Conversation podcast back catalogue is available on Apple Podcasts, Spotify, YouTube and Amazon Music, or wherever you access your media from. So if you want to take a look at our back catalogue, where we discuss a whole variety of safeguarding topics, you can find them there.